I've spent 20 years helping technology companies negotiate, draft, and defend software contracts. I've seen firsthand how a poorly negotiated agreement can cost a vendor far more than the deal was ever worth. If you're a SaaS founder or software company selling to businesses, the contract you sign isn't just paperwork, it's the legal foundation of every customer relationship. Hi, I'm Robert Melton, founder of Rob Melton Law. Today, I'm walking you through 10 key areas you need to understand and negotiate in every software agreement. These guidelines will help protect your business, secure your intellectual property, and limit your liability. The first area we will discuss is the indemnification. An indemnification is a promise by one party to cover the other's losses if things go wrong. This can involve defending a lawsuit or reimbursing costs. The vendor indemnification typically covers intellectual property infringement, data breaches, and claims from gross negligence or willful misconduct. Push back on broad, open-ended language and limit the scope to what is actually your responsibility. On the other hand, the customer indemnification protects you when the customer's data or misuse of your platform causes third-party claims against you. Don't overlook this. Another crucial area is the limitations of liability. This is easily one of the most important clauses in any SaaS agreement. The aggregate liability cap sets a ceiling, typically 12 months of recurring fees, on your total exposure. The exclusion of consequential damages removes liability for lost profits, lost revenue, and lost data. If your software has downtime, you need this clause to protect you from massive claims of lost profits. Be extremely deliberate about what carve-outs you accept, as they represent unlimited liability that could bankrupt your business. The next area I will discuss is warranties. Warranties are promises about your product that it performs as documented and services are performed professionally. Only make warranties you are absolutely confident will always be true over the contract term. The danger lies in implied warranties. Unless you disclaim them, the law may impose standards you never agreed to. A proper disclaimer, typically written in all caps, limits you strictly to express written warranties. This explicitly disclaims implied standards of merchantability or fitness for a particular purpose. For software vendors, intellectual property terms are key. The contract must state clearly that you own your platform code and algorithms. Customers get a limited license to access the service, not ownership of the underlying technology. Be extremely careful when building new features based on specific customer feedback. Ensure you own or have a license to those improvements before incorporating them into your main product. Giving away ownership of improvements can hand a customer rights to your product. Next up, confidential information. Both parties will inevitably share highly sensitive information during the business relationship. The clause should clearly define what counts as confidential and restrict its use to the purpose of the agreement. It must strictly prohibit disclosure of your confidential information to any third parties. This shields your pricing, platform architecture, and future product roadmap from public exposure. It also prevents competitors or clever customers from trying to copy and replicate your platform. Our sixth topic is the software license. Specify precisely what you are selling, who can use it, how many users, and for what purpose. Be clear on seats, geographical limitations, and the exact duration of the license. Include strict restrictions against reverse engineering, sublicensing, or duplicating your proprietary code. Vague license language is a vendor's enemy. If the scope isn't clear, customers will push boundaries. Clear boundaries make enforcement straightforward and protect your recurring subscription revenue. If your software touches customer data, data protection terms are hotly negotiated and legally required. Ensure the data processing agreement allows you to use data as your service requires. If you handle personal data under GDPR, CCPA, or HIPAA, compliance is absolutely mandatory. Be comfortable with the breach liability you accept and secure comprehensive cyber insurance. A well-drafted data protection clause protects both user privacy and your firm's reputation. Now we turn to customer support. Define your minimum support obligations, response times, and communication channels precisely. Enterprise customers often require a service level agreement with specific uptime guarantees. When service level targets are missed, the remedy should be limited to service credits, not cash damages. Ensure you explicitly disclaim cash damages or contract termination for minor service interruptions. Mismatched expectations lead to disputes, so resolve them in the contract, not in litigation later. Number 9 on my list is fees. Specify exactly when payment is due, whether upfront, net 30, monthly, or annually. We strongly recommend annual contracts paid upfront to improve cash flow and reduce churn. Include late payment interest and the right to suspend service for non-payment. Reserve the right to increase fees on renewal with reasonable advance notice. Clear payment terms ensure stable revenue and minimize time spent chasing unpaid invoices. Finally, we come to termination. Termination for convenience lets either party end without cause on 30 to 90 days notice. Many enterprise software vendors do not accept this clause. Automatic renewal terms protect your recurring revenue unless timely notice of non-renewal is given. On termination, clearly address data return, deletion, and any transition assistance needed. Ensure key provisions survive termination, including confidentiality, liability limits, and indemnification. Minimizing end-of-relationship disputes starts with a clear, structured termination clause. Today, we have covered 10 key areas in every SaaS software contract. The terms you negotiate directly affect your risk exposure, your revenue, and your business. Understanding these issues puts you in a far stronger position at the negotiating table. If you're looking to tighten up your agreements, visit robmelton.com to learn more and contact me today.